Today's post is for the 40 and 50-year-olds. At this age, you're likely to have settled into your chosen career, likely to be married or be in a long-term de facto relationship, and you're likely to have children. If this is the case, then this post is for you. Now is the time to get your affairs in order, and that includes having a valid will, enduring power of attorney, and other relevant estate planning documents in place. Why is that? Well, if you don't have a will, the government decides what happens to your estate. What happens? If you pass away and your estate is less than $50,000, then your spouse, which includes your de facto, will get the whole lot. If your estate is more than $50,000, then your spouse will receive the first $50,000, and of the balance, your spouse will receive the 1/3 of the balance, and your children will receive 2/3 of the balance. And if your children are minors, that is under 18 years of age, their inheritance could be managed by the public trustee. Do you want that? Maybe not. Now, you may have adult children, and in most cases, in most wills, you would like to give your estate to your spouse, and if your spouse predeceased you, you want your estate to be divvied up amongst your children. Now, consider this. If any of your children are in a rocky relationship, separated, bankrupt, spendthrifts, they love spending money. What else? Drug, alcohol, gambling addicts, or just don't handle their money and finances very well, then what happens is that when you and your spouse pass away, they will receive their inheritance outright, and they can, if they separate, ex-spouse can receive the whole lot. If they go bankrupt, then the trustee in bankruptcy can get the whole lot. And of course, if they're gamblers, if they're drug addicts or alcohol addicts, then the liquor stores, the casinos, the drug dealers, they could receive the whole lot as well. Do you want that? Most people think, can't do anything about that, but you can. And this is where an estate planning lawyer can help you. Estate planning lawyers, we generally have a toolkit, and we bring this with us when we see you at the initial meeting. A tool in our toolkit, one of these is called a testamentary trust. You may have heard this term, testamentary trust. How does it work? Well, instead of your child receiving their inheritance outright, their inheritance is placed into a trust. So we're basically bubble wrapping their inheritance. Okay, so there's cash in there, maybe some shares, maybe some property, your super life insurance in this trust. And while things are good, your child can access the assets in that trust. But if they're bankrupt, separated, addicts, unable to manage their affairs properly, then any creditors and predators, i.e. trustee in bankruptcy, ex-spouses, creditors, they cannot attack the assets in this trust. It's protected. Your child can still benefit from it, but during these circumstances, they cannot control it. And it's a really good strategy to have. Speaking of adult children, if you do have a will, you may have done it like 20 years ago, right? And your children are minors. Consider whether now is a good time to change your will to provide for your adult child to be your executor. So an executor is a person that applies for probate and then distributes your estate in accordance with your will. Consider also whether your child is old enough to be your attorney under an enduring power of attorney. An attorney under an enduring power of attorney makes financial and legal decisions for you if you're unable. And generally, your child is someone you'd like to appoint when they're of that age. So these are some of the issues we encounter when we do talk to 40 and 50-year-olds. Of course, there may be issues that are particular to your circumstances, and we can help you with that. Yesterday, we saw a blended family, and we talked about the idea of a mutual will, or mutual will agreement, and that's another tool we have in our estate planning tool. So if you'd like me to visit you with our estate planning tool and create together an estate plan, more than happy to. You see our fee guide above, so you can see what we charge for our services. Give us a call or send us an email, and have a great week. Speak to you soon. Bye.